The state prosecution and the defense for inmate Quadajah Johnson are duking it out in court. The state arrested Quadajah Johnson and held her with no bond. The defense asked for a bond. The state refused, not once, not twice, but 3 times. The defense appealed that decision through the appellate court. The appellate court granted the appeal and said, release her. The state asked the appeal court to hold off on that decision while we appeal the appeal. The appellate court said, sure, fine, we'll pause it. Then they granted a stay. The defense fired back saying, what the heck? Take that back. My client is ready to go home. The state interceded with another filing saying, here's why you shouldn't listen to the defense. That inmate is dangerous. The appellate court ruled again, and this time they said, nah, we ain't taking back nothing. This fight is headed to the Supreme Court. When people do the most, I do the analysis. Let's go. Quadajah Johnson won her appeal. So why is she still sitting in jail? The short answer is, it's about timing, strategy, and a legal move that most people don't understand. Some people think this phase is about the defendant's guilt or innocence. Well, it's not. During this pretrial phase, with all the motions and filings that we're seeing on nearly a weekly basis, the thing to focus on is whether the defendant, Quadajah Johnson, is a threat to the community based on her actions that landed her in the Cook County Jail. We're so far past whether she killed Ramika Blackman. We know she did. Quadajah admitted that she did. The trial phase will determine whether that killing was justified due to self-defense or whether it was an unjustified use of legal force, a murder, an intentional murder in the first degree as charged. So until we arrive at the point where Quadajah Johnson's guilt or innocence is discussed, we're here today to talk about the most recent filings in April from both the state prosecution and the defense in the Illinois 1st District Court of Appeals. In its latest filing with the appellate court, the state walks the appellate court through the timeline to frame things in their favor. The prosecution said, Quadajah Johnson is charged with 6 counts of first-degree murder. We arrested her on December 3rd. The defense filed a motion for a pretrial release on December 4th, and the trial court denied pretrial release. The reason? Because she is deemed to be dangerous and a threat to public safety and the community. The defense filed an appeal for release, claiming that the state failed to prove that their client is a threat. The appellate court accepted the case, reversed the trial court's decision with Justice Mitchell's dissent, and sent the case back to Judge Clancy to set release conditions for the defendant during pretrial. Well, the state then filed a motion to stay the mandate to give them time to appeal the decision to a higher court, the Illinois Supreme Court, that is. The appellate court granted the stay, this time with all 3 justices in agreement. So the defense then asked the court to reconsider the stay, claiming that the state is violating the inmate's constitutional rights. The prosecution has essentially laid out the complete timeline to show that they did everything by the book. But, there's a plot twist. After the appellate court ruled that Quadajah Johnson should get a pretrial release hearing, and the state stepped in and hit pause by filing a stay of the mandate, everything stopped. Just like that. Now let's really think this through, because on the surface, this may not make a lot of sense to a lot of people, because Quadajah Johnson, she wins her appeal. The court says she shouldn't be held like this, but then she still doesn't get out. To understand this, you have to understand what the state argued and why the appellate court agreed. The state came in with one core argument. The defense is mixing up 2 completely different timelines. Let's discuss that right now. There's a clock number 1. In these type of cases, the mandate, the order that sends the case back to Judge Clancy's trial court, it goes out fast. In about 5 days. But then there's clock number 2. The state has 35 days to take this case to the Illinois Supreme Court. 2 clocks, 2 different speeds, and they don't line up. Now think about what happens if nobody presses pause. That 5-day clock will run out first, and the case goes back to the trial court. And suddenly, Quadajah Johnson could be walking into a bond hearing, possibly even getting released, before the state even finishes deciding whether or not to appeal. So the state said, we need to freeze this process. They pointed to court rules that allow them to do exactly that, to pause the mandate while they prepare a petition to the Illinois Supreme Court. This is not about winning. At least not yet, it isn't. It's about buying time. So the appellate court made its decision and said, no, we're not reconsidering nothing. But the trial court doesn't actually regain control, not until that mandate gets issued. If the mandate goes out, then the trial court takes over again, and things start moving really fast. But the stay, it stops all of that from happening. Let's talk about why the defense lost the reconsideration request. The defense argued that the state only had 5 days to act, but the appellate court agreed with the state that's a misunderstanding. The 5-day rule controls speed. The 35-day rule protects the right to appeal. And the appellate court wasn't going to cut that right short. So they denied reconsideration, and the stay remains in place to this day. So right now, Quadajah Johnson is not being released from the Cook County Jail, and you can expect her to remain behind bars for at least the next 30 days while the state prepares for its Illinois Supreme Court filing. During this waiting period, Judge Clancy's trial court is officially on pause, and the entire case itself is stuck right here, waiting on one decision. But let's take this one step further, because a lot of people are wondering whether the Supreme Court will step in, and if they do, what does that actually look like? When a prosecutor loses at the appellate level, like what happened here in the Quadajah Johnson case, they don't automatically get another appeal. They have to ask for permission. That request is called a petition for leave to appeal, or a PLA. When filing a PLA, the state prosecutor must convince the Supreme Court that this case involves a question of substantial importance, or that it conflicts with other appellate decisions, like the appellate court decision to reverse Judge Clancy's denial of pretrial release for Quadajah Johnson. And remember that 35-day clock we just talked about? Well, this is what it's for. The state has up to 35 days to file that petition with the Illinois Supreme Court. And that stay that we talked about, the one that the appellate court granted to the state, it's buying the state time to prepare this exact move. And listen, these are very important filings that can't be rushed in just 5 days. But here's the catch. You don't get on a Supreme Court's calendar just by filing paperwork. If only it was that simple. The state has to convince the Supreme Court that the Quadajah Johnson case involves a question of substantial importance, meaning this issue goes far beyond just Quadajah Johnson, that it affects how courts operate across the entire state of Illinois, not just Chicago, and that it conflicts with other appellate court decisions. Now, if they can't show that, this case is going nowhere fast. The case won't get in. Period. There's also another option, though, even though it's used less often, and that is the state can ask the Supreme Court to step in using something called supervisory authority. Supervisory authority is the constitutional power that gives the Illinois Supreme Court total administrative control over all lower state courts, the circuit court, and the appellate court, in order to ensure that justice is served. It essentially allows the Supreme Court to issue direct supervisory orders to correct the lower court errors, manage judicial conduct, and to handle the administrative matters. That's when the Supreme Court argues that a lower court stepped outside its authority and the Supreme Court needs to come in and fix it now. But this is rare, and it's a lot harder to pull off. But come on, y'all, we gotta admit that stranger things have happened in this case so far. So never say never.
I would never.
Now, if the Illinois Supreme Court does accept the case, that means everything's back on the table. Because they can affirm the appellate decision, they can reverse it, they can vacate it, or they can send it back down for further proceedings. In other words, the Illinois Supreme Court can completely reshape what happens next. But if the Supreme Court denies the petition, which is a very likely outcome, and I'm not trying to put that in the atmosphere, but we do have to be honest with ourselves here. But if they deny the petition, then the Appellate Court decision to release Quadajah Johnson with pretrial conditions, it becomes final. No more delays, no more pauses, and the case moves forward toward trial. Technically, the state could try to go even further to the U.S. Supreme Court, but only if there's a federal issue involved. And that's a much higher bar, meaning that the standards, the requirements, even expectations for success are significantly more demanding or difficult to meet at the U.S. Supreme Court level. So now, y'all have the full picture. The state isn't just delaying this case for the sake of a fight. They're positioning themselves for one last shot. But whether that shot even gets taken is completely up to the Illinois Supreme Court. Just because the state can appeal doesn't mean that the Supreme Court will hear it. Let's talk reality for a second. Out of all the cases that try to reach the Illinois Supreme Court, only about 5% get accepted. That means 95% don't make it. So statistically, this case could very likely stop right here. But, this isn't just any case. This case deals with pretrial detention, a newer legal framework. I'm talking about the Illinois Pretrial Fairness Act that was signed into law in February of 2021, and it officially went into effect on September 18th, 2023. That's only 2 years prior to the Quadajah Johnson murder case. And lastly, this case deals with procedural rules that courts are still figuring out. And when the law is still evolving, that is when the Supreme Court will step in. The Supreme Court won't be asking, did the Appellate Court get this right? They're more interested in whether this issue matters for the entire state of Illinois. So where does this case land? Let's think it through. There's some reasons that the Supreme Court might take it. Because of the new legal territory, it affects future detention cases, and it raises repeat procedural questions. But the reasons they might not is that there's no clear conflict between the courts. It could be seen as a case-specific situation, and the High Court is extremely selective about the cases that they take. So this case is sitting right in a gray area. So I'm going to be real about it and make a final prediction. Normally, we're looking at about a 5% chance that this case will be accepted by the Illinois Supreme Court. But with everything going on in this case, maybe there's about a 10 to 15% chance that the Illinois Supreme Court will hear this case. But let's not lose focus, y'all. This entire situation is not about Quadajah Johnson's guilt. It's not even about the evidence in this case. It's about timing, control, and strategy. And right now, the state just bought itself more time. The Appellate Court backed that move. And now, everything comes down to one simple question. Will the Illinois Supreme Court step in? Or let the appellate decision stand so Quadajah Johnson can pack up her bag and go home? If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think the state prosecution has what it takes to get this pretrial decision in front of the Illinois Supreme Court? Or will the stay get lifted so Quadajah Johnson can be released until trial? Meet me in the comments. We can continue the conversation there.